Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Harper v. Paradise. This case was heard in the Supreme Court of Georgia in the year 1974. Let's go ahead and jump into the facts of the case. So Harper, Susan Harper, originally owned a large farm in Georgia, about 100 acres. Susan Harper wrote out a deed conveying this farm to her daughter-in-law, Maud Harper, for her life, with a remainder in her children. So there's this deed that gives Maud Harper a life estate, and a remainder interest goes to her children in the farm. This deed was written in 1922. It was given to Maud Harper then. Maud Harper subsequently lost this piece of paper. She couldn't find it. And then afterwards, Susan Harper died. So the property, the farm, went to Susan Harper's children. Susan Harper's children knew that it was her mother's intention to give the farm to Maud Harper. So what they did was they executed a new conveyance as heirs to Maud Harper in the year of 1928. This new conveyance is important because it does mention the prior conveyance that was given in 1922 to Maud Harper. So it says there is another deed that was given in 1922. That one's lost, so we're going to give her a new deed in 1928 to this whole farm. So Maud Harper gets this farm, everything's hunky-dory. Probably could have been worse than it was, but the family was really cool about it. And then in 1933, Maud Harper gets a just straight up $50 loan, and she secures it with this farm. She fails to pay back the $50 loan, and so her lender just foreclosed upon the full farm, went to the sheriff's office, took title of the farm, said it's mine now, and that was underneath the 1928 deed. So the creditor gets the deed gets their right from the 1928 deed, right? So it seems gross that someone could foreclose upon a $100 or 100-acre farm for $50. I mean, this was in the 1930s, but still, that seems like very little money for that much property. Regardless, so the creditor, Thornton, forecloses on this, and then there is an unbreaking chain of title from Thornton to the Paradises. The Paradises are the defendant in this case. So there's an unbreaking chain of title there. The Paradises chase back their title to the 1928 deed given from the heirs of Susan Harper to Maud Harper. So some time goes by, and the original deed actually turns up. One of Maud Harper's children find the original deed that gave her the life estate and then the remainder to her children. So these kids are like, whoa, what is this deed? We have this farm. You can imagine how excited you would be when you see that. So they go to say, well, this is our farm. But the Paradise is like, no, this is our farm. We have good title from Thornton when it was foreclosed upon when Maud Harper didn't pay her $50 debt. So the court has to decide whether they're going to say the 1928 deed is going to rule or the 1922 deed is going to rule in this dispute. There's some arguments put forth by the defendants that cite Georgia's statute and say that the 1928 deed should be the primary one, and that's the one that once that 1928 deed was executed, the prior deed was basically just garbage at that point. The court rejects that argument and says that they're going to give primacy and right to that 1922 deed. And the reason they're going to do that, they say, is because the 1928 deed references the deed in 1922. So it references the lost deed in 1922. So the court says that any diligent title researcher would have found that, oh, this 1928 deed references a lost deed. What is this lost deed? Let's look into this lost deed. And they're saying that because they failed to do that, they were put on notice, they were put on constructive notice that there was this prior deed in 1922, and they failed to do anything to ascertain where that was at, or who had the property right underneath that deed. And so they're saying that the title search failed to actually procure the property. So the court rules in favor of the remainder men, and the farm is retaken back. I think this is an interesting case because we feel bad for the Paradises. Likely they didn't do the title search themselves. Likely they hired someone. This is kind of an abstract thing, and now how, they feel like they're screwed. Hopefully they had some title insurance. But I think we feel good for the Harpers because that $50 loan in 1930 essentially was what's, rid them of their right for a 100-acre farm in Georgia. There's also a claim that the Paradises put forth about adverse possession. They say that they were able to adversely possess this land even if they didn't have true title because they were on the property. The court rejects that argument pretty quickly, and they say that because the 1922 deed rules, it gave a life estate and then it gave a remainder to the children, and the remainder for the children didn't actually take place until the death of Maud Harper, and for that reason there hasn't been a continuous occupation for the statutory period to satisfy adverse possession. So that's the case. A little bit of an ex ante discussion. It just shows the importance of deeds that are more primary, right? And if a subsequent deed references a more primary deed, but the subsequent deed is recorded, you should still try and look to find that other deed that's not recorded, right? Because the court is going to kind of reject this idea that recording is like the ultimate gold standard for property rights, and say that there's other things that exist, and recording is a nice service that the government gives to help title searchers and prospective purchasers of land discern who actually owns that land. They're going to say that, well, that's not enough to guarantee that person actually owns the land. So this likely is going to increase, a ruling like this is likely going to increase the cost of purchasing land, right? Because the title search prices are going to go up, title insurance prices are going to go up when they see rulings like this. But ultimately what the court is saying is that recording is nice, but recording isn't sufficient to guarantee your property right. So thanks so much for watching. I hope you enjoyed this video. If you'd like to see more, go ahead and hit that subscribe button. I hope you have a nice rest of your day. Bye-bye.